She would strongly urge the trial courts, at the request of the defendants, include the mitigators in the jury's finding on the mitigators, especially in light of Hurst. And that's in the rules that you're reading.
Understood. I also noted that it was contrary to the majority. I read her portion as well as Labarge's and Quinn's. All right. Here you all go. Here are the two sets of the jury instructions. Here's also what the court had indicated, which are placing the mitigators in the number order that they otherwise would have been listed, on the verdict form. All right. At this point, the court is going to get the jury and instruct them on the closing arguments. Are you still at 45 minutes each, do you each think?
I think so.
Mr. Leichel?
Yes, ma'am.
Okay. And do you want a time frame that you want me to stop you, Mr. Stone, for rebuttal?
Well, there is no rebuttal, Your Honor.
Oh, yes, I'm sorry. You're right.
You know, I'm thinking,
Are you going to be less than 40 minutes?
well, no, I'm kind of thinking, I don't want to cut myself too short. I'm thinking maybe an hour, but I won't be an hour. But I don't want to start rushing towards the end.
Why don't we try for 45 minutes? You're welcome. You may be seated. Members of the jury, both the state and the defendant have now rested their case. Their attorneys will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in your understanding of the case. Each side will have equal time. The state will go first and then the defense. Mr. Stone, you may proceed.
Thank you. Judge, you have the laser pointer? Yeah, can I use that one, please? No. Thank you very much. I have to figure out how to use it. Here, I'll show you. Multiple buttons. Well, thank you very much. We all thank you for the attention that you've given this case. And we're almost done. The judge is going to give you a very detailed set of jury instructions when you go back and deliberate. And you'll have a written set of instructions to take back with you. As a matter of fact, each one of you will have a written set of instructions to use and to refer to, because it can get a little confusing if you don't have the written set of instructions. And what I'm going to start out with is try to describe, and I'm kind of going to pattern myself off of what the judge will be instructing you on, and also the written instructions that you'll get. I'm going to try to go through the process that you need to go through in order to impose the death penalty. And it's multiple steps, once again, all set forth in the jury instructions. But in order to impose the death penalty, you must, number one, unanimously find beyond a reasonable doubt that at least one aggravating factor has been established by the prosecution, by the state. That's the first step. If you do that, if the answer is yes, then the second step is you have to unanimously find that the aggravating factor or factors that you found established are sufficient to justify the death penalty. Once again, this is all going to be set out in the written instructions. That's step two. If those two steps, if the answer is yes to those first two steps, then you must determine whether any proposed mitigation that was put forward by the defense has been proven by the greater weight of the evidence. The judge will instruct you what that means, the greater weight of the evidence, going to be in the written instructions. And with regard to that particular finding, the jury need not be unanimous in finding that particular mitigating circumstances. It's an individual decision that each juror makes on his or her own. Then, after reviewing and considering the mitigating evidence, and if you find that any mitigating evidence has been established by the greater weight of the evidence, there's a fourth step. And the fourth step is you then must determine whether the aggravating factor or factors that you find exist outweigh the mitigating circumstances you find proven. Now, as I will talk about in a few moments, and as has been repeated to you many times, it's not simply a mathematical calculation, and that's something that cannot be impressed upon you more. It is not simply a mathematical calculation. There are going to be numerous mitigating circumstances that have been put forward to you and that are going to be argued. And I'm going to talk a little bit later on whether or not it's within your authority to simply reject a proposed mitigating circumstance. And the answer is yes. But I'm going to talk about that a little bit later. And of course, it's a two-way street. You can reject outright an aggravating circumstance that's been put forward to you. But the point is, it's not a mathematical process where you just simply come up with a number regarding the mitigating circumstances, come up with a number regarding the aggravating factors, and then, well, more aggravating factors than mitigators, or more mitigators than aggravators. The one who has the most numbers wins. It's not that type of process. It's the quality of the factors that are presented to you. And once again, I know I've said it several times, you've heard it several times, but that cannot be overemphasized. It's the quality of the factors. And then finally, the fifth step. If you unanimously find beyond a reasonable doubt the existence of one aggravating factor, that aggravating factor or factors justify the death penalty, and that aggravating factor or factors outweigh any mitigating circumstances that have been proven to you, after all of that, then the fifth step is the actual decision that's recommended or given to the judge, whether it be the death penalty or life in prison without the possibility of parole. So I know it's a mouthful and it's a lot, And as I said already a number of times, you're going to have written instructions that specify in detail the process that you go through while you do your deliberations. So, what are the aggravating factors that have been put forward and proven to you beyond a reasonable doubt? Well, the first aggravating factor is that the murders were committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Now, the judge is going to give you an instruction on that particular aggravating factor. And in that instruction, the judge is going to define certain words contained within that aggravating factor. And the first is cold. The judge is going to instruct you that cold means the murder was the product of calm and cool reflection. I want to talk about that. I'm going to talk about the others also, calculated and premeditated. The murder was the product of calm and cool reflection. Let's talk about the evidence. And now I'm going back to the evidence in the first portion of the trial, the phase 1 of the trial. By his own admission, the defendant was with his mother all day. That's in the interview that he gave to Investigator Anderson and Investigator Multari. By his own admission, he was with his mother all day. Sometime in the very late afternoon, and we know that the last human activity on Margaret's computer was at 4:44 p.m., the defendant executes his mother by shooting her once through the head. From the time he murders his mother, the defendant waits for his father to arrive home from work at approximately 5:30, a little bit after 5:30. During that time, the defendant's mother is sitting face down dead at her computer desk. After his father arrives home from work, and while he's in the kitchen with his back to the defendant coldly walks up from behind and shoots Chad, his father, once in the back of the side of the head, immediately incapacitating him. Chad then falls down to the floor, but still alive, obviously, because you can see from those photographs that he crawls around the island that's in the kitchen. And while face down, the defendant then executes his father with the second bullet. He shoots him right through the head. For over 4 hours, with the body of his dead mother and father in the house, the defendant waits for Cody to come home. When Cody comes home, he arrives home at around 10 p.m., and while he walks through the threshold of the door that leads from the garage into the house, the defendant executes, and that's the word, executes, Cody with one shot to the face that goes through his head, immediately killing him. By any definition of the word cold, these murders were cold. By the definition that of the word cold that Judge Rex Seidler will give to you, these murders were the product of a calm and cool reflection. Once again, that's the definition that the judge is going to give you with respect to the word cold. The product of calm and cool reflection. Calculated. Well, the judge is going to instruct you that calculated means having a careful plan or prearranged design to commit murder. That's the definition that the judge is going to instruct you. The definition of the word calculated. What the defendant did in this case is he wanted to, and effectively did, stage a murder-suicide. There is no question that he planted those 4 shell casings, and he planted that gun near Cody's body. The shell casings matched the gun, once again, the gun near Cody's body, but the bullets were absolutely excluded from having been shot from that gun, which means the defendant had to have fired that gun, Cody's gun, 4 times at a time other than the murders. Remember the testimony of Jennifer Sawyer? One of the last witnesses to testify, her testimony was that she heard multiple shots in succession the evening of January 24th, 2019. And my recollection of her testimony was that it was later in the evening, around 8:30, I think between 8:30 and 9:30 she testified, which would have been at a time that was after Margaret and Chad's death, but before Cody's arrival and his death. You remember her testimony? So he had to have planted those bullets, and he had to have shot those shell casings, and he had to have shot Cody's gun at a time other than those murders. Then he picks up those 4 shell casings, and then with a gun other than Cody's, once again the gun that was found near Cody, he kills his mother, his father, and his brother. Then he plants those 4 shell casings from Cody's gun, and he places Cody's gun near Cody's body. Once again, this all goes to the calculated part of the code, calculated and premeditated. And to complete the staged murder-suicide, to give the appearance of some kind of confrontation between an armed Cody and an armed Chad, he rolls Chad over on his back, and he placed that holster on Chad's right hip. We know that the defendant rolled Chad over on his back because the second shot was to the back of Chad's head. And that certainly was the fatal shot, which means that Chad could not have rolled over by himself. And we know that he was face down when he was shot, he, meaning Chad, shot in the back of the head, because the entry wound of that bullet in the back of the head, the entry wound was the wound to the back of his head. And we know that there was the impression on that tile that was found, that was identified a few feet, a foot or 2 or whatever, to the right as you look at Chad's body, to the right of his body. So we know that bullet went through his head into that tile, and they recovered that bullet. So we know that he was face down when he was shot and when he died. So he was rolled over. Unquestionably, he was rolled over. And additionally, the evidence clearly shows that Chad was right-handed and would never have placed that holster in the reversed position on his right hip. Do you remember that? That holster was not in the position it would be for a right-handed person. It was reversed. Once again, by any definition of the word calculated, these murders were calculated. By the definition of the word calculated that the judge will give you, these murders were the result of a careful plan or prearranged design to commit murder. Premeditated. Once again, cold, calculated, and premeditated. Well, premeditated is the judge will instruct you, is the same definition that you were given during the first part of the trial. And I'm going to put it up on the overhead now. But there's also one additional requirement that makes this type of premeditation part of the cold, calculated, and premeditated aggravating factor. But let me put something up on the overhead and talk about it. Now, you see something else when I put on the overhead. Something else is highlighted. I'm going to talk about that highlighted portion with regard to the next aggravating factor that we'll discuss. But first, now I want to talk about the premeditated prong of the cold, calculated, and premeditated aggravating factor. This is the definition of premeditated, and that's what was given to you during the first part of the trial. And you'll see, killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection. The premeditated intent to kill must be found before the killing. This is the second part of the definition of the premeditated prong. However, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. A substantial period of reflection. That's the thing that makes what I'd call the regular definition of premeditated into the premeditated prong of the cold, calculated, and premeditated aggravating factor. A substantial period of reflection. Well, he had all day to think about and reflect on murdering his mother. Once again, Grant Amato admitted in his interview with investigators Anderson and Malteri that he was home with his mother all day the day he murdered her. She was murdered in the very late afternoon. Once again, we know the last human activity on that computer was 4:44 p.m. So she was murdered before Chad got home, very late in the afternoon. So the defendant had hours upon hours upon hours to reflect on murdering his mother. And he decided to do so. With regard to Chad, his father, the time between murdering his mother and murdering his father was approximately less than an hour. I mean, the evidence shows if we establish the time of killing of Margaret sometime in the very late afternoon, 4:45 to 5 p.m., and Chad arrived home just after 5:30, we're talking a time period of 40 to 30 minutes that he had to reflect, which is certainly a substantial amount of time to reflect and think about murdering his father when he arrives at home. But there's also one other thing I would like you to remember about this case. That there's certainly evidence in this case from which you can find that these murders were pre-planned and designed well before January 24th, 2019. Such as the planting of the evidence, namely Cody's gun, the shell casings, and that holster that was found on Chad's hip. His all-consuming obsession with that woman in Bulgaria, Sylvie. His absolute contempt for his family by ending his relationship with Sylvie, which was tantamount to ending his world as he believed it to be. All of this as demonstrated in that letter that he wrote to his chat room companions, which is in evidence, and certainly you can refer to during this part of the trial. Once again, the evidence in the first part of the trial, as it pertains to aggravating and mitigating circumstances, is certainly something you can review and consider. So I ask you, when you consider about the premeditated part of this case, look back at that letter and then ask yourselves, are the seeds then being planted for what he did? And you'll see from that letter his absolute obsession with this woman and his absolute contempt for his family for ending his world as he believed it to be by terminating his relationship with Sylvie and revealing to this woman who he really was. That certainly allows you to infer and certainly gives you the basis to plausibly find that this was something that was conceived well before January 24th, 2019. With respect to Cody, it was over 4 hours. Remember, Cody arrived home sometime around 10 p.m. It was over 4 hours from the time that he murdered his father to the time that he literally lay in wait and murdered Cody as Cody walked through that door. Over 4 hours. And is there any question that he was thinking about doing, what he was thinking about doing, what he was reflecting on the second Cody walked through that door? Is there any question about that? What does the evidence show you? That Cody was shot the second he walked through that door. And you remember the testimony of Christine Snyder, where she said that she actually stood by that wall and she smelled gunpowder? Do you remember that testimony? That was the wall this is the wall, and this is the door from the garage into the house. And Christine Snyder's testimony was that she smelled gunpowder over there. So is there any question that he was waiting for the second that his brother Cody walked through that door, and the second he walked through that door, shot him right in the eye? The last thing that Cody saw, probably, with the bullet going right underneath his eye, was his brother killing him. And once again, as I just noted a couple of moments ago, there is certainly evidence that allows you to conclude that these murders were planned and thought about well before January 24th, 2019. And finally, with respect to this particular aggravating factor, the murders must be without a pretense of moral or legal justification. That's the very bottom paragraph here. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, and premeditated nature of the murder. Well, what is that? What is a pretense of moral or legal justification? Well, let me give you just a couple of examples, and then hopefully the point will be made. Classic examples of a pretense of moral or legal justification are that a murder was committed to end the life of a person, usually a family member, who was terminally ill or suffering, or a person, almost always a woman, who has been physically abused and kills her abuser. Those are murders, and they could very well be first-degree murders. But there is certainly, in those instances, a claim of a pretense of a moral or legal justification that would disqualify it from being a cold, calculated, and premeditated aggravating factor. None of that exists in this case. There is nothing remotely to suggest that the defendant committed these murders with a pretense of a moral or legal justification. Absolutely nothing. The second aggravating factor in this case is that Grant Amato was previously convicted of a capital felony. Now, the judge is going to instruct you, and let me put that portion of the instruction on the overhead. That first of all, the crime of first-degree murder is a capital felony, obviously. That a prior violent felony aggravator includes violent felony convictions resulting from crimes committed on separate victims during a single criminal episode. For each individual conviction of first-degree premeditated murder, you may consider the other two convictions as previous convictions of another capital felony. The judge will instruct you to that effect. The judge will instruct you that the prior violent felony aggravator includes violent felony convictions resulting from crimes committed on separate victims during a single criminal episode. The events that occurred at 2112 Sultan Circle, starting the afternoon of January 24th, 2019, and ending the early morning hours of January 25th, 2019, during which the defendant murdered his family, is a single criminal episode. With respect to the defendant's conviction for first-degree premeditated murder of his mother, you may consider his convictions for the murders of his father and Cody as previous convictions of another capital felony. With respect to the defendant's conviction for the first-degree murder of his father, you may consider his convictions for the murders of his mother and Cody as previous convictions of another capital felony. And with respect to the defendant's convictions for the first-degree murder of his brother Cody, you may consider the convictions for the murders of his mother and father as previous convictions of a capital felony. And remember, those previous violent felony convictions are for the crime of first-degree premeditated murder, a capital felony, a fact that makes them much more weighty. They are not convictions for other types of violent felonies, such as aggravated battery or armed robbery or other forms of murder, which are, of course, serious, but not nearly as serious as first-degree premeditated murder, which is a capital offense. Now, once again, it cannot be emphasized that the process is not simply a numerical process, it's the quality. It's not just simply adding up the number of aggravators versus the number of mitigating circumstances, because I expect you're going to hear argument and proffered evidence regarding numerous mitigating circumstances. Some are called statutory mitigating circumstances. Two of those statutory mitigating circumstances are that the defendant had no prior significant history of criminal activity, and the other being the age of the defendant at the time that he murdered his family. He was 29 years old, by the way. And there are what are called non-statutory mitigating circumstances. I expect you're going to hear numerous alleged non-statutory mitigating circumstances. And that's basically any aspect of the defendant's background, character, that you may feel may militate against the imposition of the death penalty in favor of the life in prison. But it's the quality of the aggravating and mitigating factors and circumstances that you are to consider, and if you find exist, you weigh against one another. And please remember, please note that I said if you find exist. And what I mean by that is evidence of aggravating and mitigating circumstances have been presented for your consideration. And of course, just like any other item of evidence, you need to consider it. But considering it doesn't mean that you accept it. It's completely within your authority, after considering it, to absolutely reject it or to give it minimal weight. That's completely within your province and authority. Now, the evidence in this case, with regard to the two aggravating factors, has been established clearly beyond and to the exclusion of any reasonable doubt. And they are very weighty aggravating factors. Cold, calculated, and premeditated, and then previous convictions for a capital felony. These are two significant and heavy aggravating factors. We're talking about a triple murder. Clearly, the law allows those two aggravating factors in and of themselves to justify the death penalty. Now, against those aggravating factors, you must weigh the mitigating circumstances that you find to exist. And I want to talk about just a few of the mitigating circumstances that have been put forward to you. First of all, there's the statutory mitigator that is alleged that the defendant has no significant criminal history. Well, in assigning that any weight, and you can assign it no weight at all if you choose to, I want to make a couple of observations. No significant criminal history. Well, once again, you can consider the evidence that was presented to you during the first part of this trial. The hundreds of thousands of dollars that was taken from his family to continue that online relationship with the Bulgarian, with Sylvie. That's something that you may consider. And you don't need to have convictions in order for you to consider whether or not the aggravating factor of no significant criminal history has been negated. It's not necessary that the state put forward to you, well, he was convicted of this and convicted of that and convicted of this. Evidence of criminal activity is sufficient to rebut or negate that particular statutory mitigating circumstance. Think of all of the money that he literally took and stole from his family to continue the online relationship with Sylvie. That's something that you may consider when you assign what weight, if any, you give to the no prior significant criminal history mitigating circumstance. What about the taking of that propofol? You heard evidence about that without authorization and without a medical doctor's prescription or authorization. He would give it to patients. You can consider that when you consider whether or not you should give any weight to the statutory mitigating circumstance that's been put forward to you of no significant criminal history. The other statutory mitigator that's been presented to you is his age. Keep in mind, he was an adult when he committed these murders. He was 29 years old going on 30. He wasn't 18, he wasn't 19, he wasn't 20 years old. He had already graduated school. He already graduated college. He was working on postgraduate work. He was an adult when these crimes were committed. He was 29 years old. Wasn't a kid. There are going to be significant non-statutory mitigating circumstances that are presented to you, and I expect that you're going to see a list, one list after another. And look at that list very, very carefully. No history of prior violent behavior. Grant Amato had no history of early violent behavior. He has the ability to adjust to structure. No history of substance abuse or alcohol abuse. Grant Amato has no history of brain or neurological impairment. Grant Amato does not have an antisocial personality disorder, and he's not a psychopath, and several others. Basically, and that's pretty much based upon the testimony of Dr. Carpenter. Basically, what that's saying is he's a normal person. He's a normal person. When you boil it down, that's what those non-statutory aggravating mitigating circumstances say. He's a normal human being. Decide whether or not you want to assign that any weight as a mitigating circumstance. A normal human being that killed his family, that killed his mother, father, and brother. Now, I just have a couple of final remarks that I want to make to you, then I'll sit down and Mr. Lyko will have a chance to make his argument. First, you'll be given a jury form, and I was going to go over it with you, but it's pretty self-explanatory, but I don't think I have enough time to do it. But it's pretty self-explanatory. It just goes through that those particular 5 choices, those 5 questions that are presented to you. And for each, for Margaret, Chad, and Cody, you'll have a separate verdict form to decide what the appropriate punishment is. But let me just close out with this. When you go back to the jury room, please consider all the evidence, as you should. Please consider all the mitigating circumstances that have been presented to you, keeping in mind that it's fully within your province to reject and give no weight to the defense's proposed mitigation, finding that they're not truly of a mitigating nature. And also remember this. Remember that you're never required to vote for the death penalty. You're never required to do that. But the issue is not whether or not you're required to vote for the death penalty. The issue is whether you should vote for the death penalty because it's the appropriate sentence. And when you consider that question, whether you should vote for the death penalty because it's the appropriate sentence, please consider the enormity of the crimes the defendant committed. Consider the enormity of what he did. The judge will instruct you that you must carefully consider and weigh all the evidence, realizing that a human life is at stake. Well, when you think that a human life is at stake depending upon your vote, once again, please think of the enormity of what this defendant did. His mother, his father, and his brother. Just think about that. And when you're confronted with the reality that it is indeed hard to vote for the death penalty, please think of the overwhelming, mind-boggling enormity of what this defendant did. With the exception of Jason, he murdered his entire family. Just think about that. I say this respectfully. Every single one of you said that you can vote for the death penalty in the appropriate case. Every single one of you said that. If there was ever an appropriate case, this is the one. Thank you.